Yeah, I think it is 7. We will get going. Just as a very brief introduction, Dr. Neeraj Nagpal is from Chandigarh. He is a physician and a GI endoscopist. And as Dr. Sarin mentioned, he is a very popular figure in the medico-legal circles in our country. He is the chairman and managing trustee of the Medico-legal Action Group. He's also been the ex-president of IMA Chandigarh. And he runs a very busy clinical practice at Hope Gastrointestinal Diagnostic Center in Chandigarh. So I think he wears many hats, clinical as well as medico-legal, as an RTI activist, writer, speaker. And he's a very popular person called to speak to gatherings such as this around the country. He's also the editor of the Journal of the Indian Medico-legal and Ethics Association and has authored several books. So without much ado, I will present to you Dr. Neeraj Nagpal.
Thank you, Dr. Rao, Dr. Sarin, for giving me this opportunity. Am I audible?
Yes.
Yes, you are audible. You are audible.
Can I start my screen share?
Please.
There seems to be some hang up. Okay. So the topic we chose today is more of an introductory topic. Are my slides moving?
We have your introductory slide, the first slide.
तुम भी देखो मेडिकल लीगल एस्पेक्ट है अभी.
We are on the first slide.
Still not moving?
Yeah, no, it's more. It's more. Yeah.
I request everybody to mute themselves, and when we have any discussions later, we will kind of allow that,
So today's topic we have chosen is more of an introductory talk, which will cover
full screen.
This is full screen from my side.
No, you can go to presentation mode down below.
Okay.
Then next to 65%, if you would click that bucket or whatever.
When I'm clicking that, on my screen, it is full screen.
All right.
No, we are not seeing as full screen. No.
Anyway, go on.
Okay.
Screen share.
So the topic we chose today was a very broad topic, and it is basically an introductory topic to medical legal issues. And if I have to describe the mistakes or categorize them, I would categorize them into following categories. That is, before a treatment has started, with during treatment, after an adverse event, after receiving legal notice, and mistakes that doctors make in court. So what are the pitfalls that are there before treatment? What are the mistakes doctors make before treatment? Among the first ones is claiming to be a specialist or a super specialist without an MCI recognized qualification. Now, any city you go to, you will find MD medicine doctors who are cardiologists and diabetologists, who are cardiologists or who are gastroenterologists or who are nephrologists. And this is rampant across the country. 20 years ago, this was probably okay. This was not norm. But today, as per the situation or as per law today, this is error which in itself will be considered sufficient to award compensation for. So many issues have arisen and they will continue to arise. So far, when you did not have DM, I think there is somebody's mic which is on, that can be muted. MD medicine, the MD pediatrics doctors claiming to be neonatologists without a DM neonatology degree. This is a gray area till now because not too many DM neonatologists are there in the country. But another 10 years down the line, the situation will be exactly the same as has happened for the MD medicine doctors. Can MD medicine claim to be a cardiologist? Can MS surgery claim to be a urologist? And we have also issues where foreign degrees, where a graduate degree is also called MD. and we had a case, I mean, way back in 1992, which was decided by National Consumer Dispute Redressal Commission. This was a missionary doctor who was practicing as a gynecologist in Kerala, and she had a problem, amniotic fluid embolism, and the patient died. So the court had said that though there is no negligence per se in the treatment, the fact that she was MD from Germany and claiming to be a gynecologist, MD of Germany was recognized as an MBBS in India by MCI. She had 4 years subsequent training in obs and gynae, also in Germany, but that training had not been recognized as equivalent to MD gynecology in India. So on that ground alone, without having made any error in the treatment part, she was penalized. When you look at the Indian Medical Council regulations of 2002, they have mentioned very, very clearly that a physician shall not claim to be a specialist unless he has special qualification in that branch. Examples, I have umpteen examples of cases. MD medicine doctor who had already done more than 10,000 dialysis patients, who had been a transplant specialist, who had conducted more than 500 transplants in the hospital. The AIMS had formed a board, and they said very clearly, membership of associations does not confer a specialist status to a doctor's concerned. So he was penalized purely on this ground. But Medico's Legal Action Group had gone to MCI under RTI, and we had asked them to tell us what an MD person can do, what a super specialist can do, and can an MD medicine practice cardiology. So the answer given was categoric and very clear. You cannot claim to be a pediatric surgeon. If you are a general surgeon, you cannot claim to be a pediatric surgeon, but you can practice pediatric surgery if you are trained in that department, in that field. So there is nothing to bar you from practicing pediatric surgery as long as you don't write a specialist pediatric surgeon on your letterhead or on your nameplate outside. So you cannot claim to be a pediatric surgeon without an MCH in pediatric surgery. This was the MCI reply, and this had been endorsed by the general body of the MCI, also by the executive committee. Malay Kumar Ganguly's case, everybody will be familiar, 11.6 crore judgment was there. This had also made it very clear that if representation is made by a doctor that he is a specialist, and ultimately it turns out that he is not, deficiency in medical services would be presumed. Even if you have done everything perfectly okay, you have not committed any error, there is no negligence in your actions, just the very fact that you claim to be a specialist in itself is sufficient to penalize you for negligence. Now comes the question, can a super specialist perform a specialist's job? Now this is a very strange situation. And in a general surgery person, can he perform a super specialist job? The answer is yes, we already know that. But the question is, can a urologist perform a cholecystectomy? Can a pediatric surgeon perform a cholecystectomy in an adult? At least one judgment, though absurd in my view, is there which says that if a super specialist in the field of surgery possesses basic qualification as master of surgery, it does not mean that he can do any surgery other than the super specialty. Unfortunately, no organization of doctors, no specialty or super specialty organization of doctors thought it fit to challenge this kind of a judgment, which is likely to create problems for more and more doctors in future years. Among the other mistakes that doctors make before starting treatment is starting a hospital without proper infrastructure or equipment. You have umpteen number of cases where hospitals, doctors have been penalized for not having ICU, for not having ventilator, for not having a CT scan in the premises where the neurosurgery is being done. So these are all, I mean, including from Supreme Court in a case which was from way back in 1996, where a hysterectomy was performed in a nursing home which did not have an ICU, and this was penalized by the Honorable Supreme Court. Ground reality, personally, I feel this was an aberrant judgment, which probably again should have been challenged, but unfortunately was not. We also have judgments against Apollo Hospital, Chennai, where they did not declare in the consent that they do not have machinery to monitor methotrexate levels. And they said that this information should have been made available to the patient party. What I fail to understand is, if I have to give information of all the equipment that I do not have in my hospital, that itself will take more than 50 pages. And after that only will I be able to come to the crux of the consent which I am actually wanting to take. But again, unfortunately, nobody bothered to challenge this judgment. These are kind of aberrant judgments which create problems later for doctors. And it is up to societies and up to associations to take up issues like this and fight them legally. One good judgment regarding this issue which came recently was in November 2021 from Supreme Court itself. This was a case of aortic aneurysm, operated, developed some decreased blood flow in the legs with impending gangrene, was made to wait in queue for DSA, and when his turn came, the machine was out of order. So CT angio was done, also for which the patient was made to wait. And on this issue, there was a lot of heated debate up to Supreme Court. And finally, Supreme Court said this is not negligence. Non-availability of an operation theatre at the time when the patient needs, when the operation theatres are busy, is not a valid ground to hold hospital negligent. Similarly, non-functioning of machines and equipments cannot be said to be negligence just because the patient could not avail of the facilities there. The hospital has the machines, and the machines will go out of order sometime or the other. Mistakes before treatment, not taking proper indemnity insurance. Government doctors seem to feel that they are immune and they do not need indemnity insurance. Resident doctors seem to feel it is not our requirement for us to take indemnity insurance. Very, very mistaken views. I can give substantial arguments on the same again, but it will take a whole hour just to give the arguments on this ground. Government doctors, resident doctors, interns, please take indemnity insurance. The problems we face is the doctor's indemnity insurance is lapsed. The person has been practicing. Yesterday, a doctor, senior doctor from Chandigarh came to me. We had a problem, left a mop inside. And for that 1 month duration, when this surgery was performed, the doctor's indemnity insurance has lapsed. Now, I don't understand. You are in private practice, you are a senior person, you know, you have heard all these things time and time again. How does an indemnity insurance lapse? You have no business to be in practice if you do not have indemnity insurance today. Inadequate indemnity insurance. Doctors come to me, Doctor Sahab, हमने तो indemnity insurance ली हुई थी, 3 लाख की indemnity insurance ली. 3 lakh indemnity insurance is toilet paper. Don't even bother to use it as a toilet paper. Today, a pediatric surgery practicing doctor, a resident should not have indemnity insurance less than 30-40 lakhs, and a practicing doctor should have indemnity insurance more than 1 CR. This is something which has become necessary today. Look at the pecuniary jurisdiction of CPA 2019, where they have taken the pecuniary jurisdiction. So this kind of 3 lakhs, 5 lakhs indemnity insurance is an umbrella which is made of paper, and it will melt the moment some rain falls. Inappropriate filling of proposal form. People seem to be very busy to fill the proposal form, and when they don't fill the proposal form properly, they have problems when they actually want the claim to be made. Now, there was a hospital, Ram Kirat Medical Institute and Ram Kirat Hospital, something like this. The name was, it was the same name, but 2 different titles were there. And the doctors in their normal practice, what they do is, I'm signing the form, so when the indemnity insurer representative fills it, he fills what he sees outside on the board. He does not fill it according to what you want. And if the hospital name is not mentioned properly in your indemnity insurance, if you do not declare appropriately to the indemnity insurers where all you go and practice, the indemnity insurers tomorrow will deny liability, and again, I can talk on 1 hour just on this issue. Umpteen number of examples I can give. So please fill your indemnity insurance form properly, spend 5 minutes, think it over and fill it. Don't leave it to somebody else to be filled. Doctors then, especially in private sector, whether in a partnership concern or a proprietorship concern or a corporate, they take a personal professional indemnity insurance, but they do not take an error and omission policy for the hospital or for the establishment which they are running. A lot of them tell me it's a proprietorship concern. So the name of the center, let us say it is Hope Clinics and Dr. Neeraj Nagpal. So if I have taken policy for Dr. Neeraj Nagpal, I don't need for Hope Clinics if this is a proprietorship concern. This is a wrong concept. Why? Patient comes to me, I have done an endoscopy of a child to remove a foreign body under general anesthesia. An anesthetist comes, I am sitting in my OPD, I am looking out at my patients. The anesthetist comes, gives the anesthesia to the child expires. I have not even seen the child. The case is going to be filed against Hope Clinics as well as the anesthetist. If Hope Clinics does not have a policy, my own personal professional indemnity insurance will not protect me. So always take an error and omission policy for the establishment plus a personal professional indemnity insurance for your own self. Then doctors take one large policy. I have doctors who come and ask me for 4 crores policy. Fine, you can take a 4 crore policy. But I personally feel you should take 20 lakhs, 50 lakhs, 1 CR and 3 CR. Multiple separate policies from the same insurer. Again, a lot of time will be spent in discussing why all this I'm advising. But multiple smaller policies from the same insurer. Don't go to different insurers for the policies. Taking policy in 1:4. Do not negotiate rates with the indemnity insurer representatives. When you negotiate rates with them, they usually down categorize your policy from 1:1 to 1:4, which then means if you have a policy of 1 CR and a claim of 50 lakhs is made against you and 50 lakhs is awarded, the company will pay only 25 lakhs. 25 lakhs you will have to pay from your pocket. Unqualified attendant care, 7.5% is the loading. It is so easy, so cheap. Please take it. All of us have unqualified attendants in our establishments, in our hospitals, and they need to be covered. Not reading the policy terms, please go through the policy terms. And this is a very strange situation which has arisen. Tomorrow, after my death, should I ask my legal heir to continue taking the indemnity insurance? Why? Because the case does not finish with the death of the complainant or of the opposite party. So a claim which has arisen against me will be maintained against my estate and against my legal heirs. So if the claim is going to be maintained after my death, should indemnity insurance be taken after my death? Under RDI, IRDA, United India, New India, I have gone to everybody, nobody has an answer. Tomorrow, sometime or the other, an issue like this will arise and we'll have a judicial answer to the issue which I have raised. Government sector, this complacency, one particular case I will mention, please go and read this. V. Krishna Kumar versus State of Tamil Nadu. A total of 2,28,87,921 rupees was awarded in this particular case. Sudha Garg versus Union of India. This is a purely army hospital. Army people think they don't require anything. 12 lakhs was awarded in this. I can give you details of cases, innumerable numbers, but army hospitals, ECHS, CGHS, whatever establishment you are in, one way or the other, either under Article 226 and Article 32, you either under that or under Consumer Protection Act or in civil suit, somewhere or the other, you can be held liable for negligence. So it is advisable that indemnity insurance is taken by doctors in government hospitals, in polyclinics, even the resident doctors. I haven't given you examples of resident doctor cases, but there are a number of examples there. If you are operating in multiple centers, please mention this in your proposal form. Error and omission policy versus professional indemnity. I've already told you, individual establishments need to be having a separate policy over and above the personal professional indemnity insurance. Then, before you start treatment, you are supposed to take consent. What happens in our consents? Either we are not taking the consent at all, or taking consent from a relative instead of from an adult, competent, conscious patient. Now, if the person is more than 18 years, if the person is conscious, the right to give the consent is only of that person. Now, you are a gathering of pediatric surgeons, so you are dealing with pediatric population. Yes, under the circumstances, if the child is less than 12 years, it is only the guardian and only one guardian is needed. You don't need the signature of both the guardians to go ahead and operate on the child. For children between 12 and 18 years, we always advise that you take the signatures of the guardian as well as of the child. More than 18 years, it is only of the patient which is important, not of anybody else. Then doing something more than what the consent has been taken for. If you have taken consent for an X procedure, do not start doing Y procedure just because you think the patient will unnecessarily have to be brought out of anesthesia, will have to be explained, given anesthesia again, and taken up for a second surgery at a later date. Do not think that the patient, it will cost the patient more. All this is very well mentioned in the Samira Kohli judgment. So do only exactly what the patient has given consent for. Do not extend just because you feel that what you are going to do is in interest of the patient. Consent not being in the same language as patients, no signature of surgeon. Remember, consent is a contract. If you see the definition of consent in Indian law, the only place it is defined is under Indian Contract Act. And a contract is always between two parties. Sending a nurse to get a signature on the consent form, that consent form is invalid per se if you haven't signed it. No consent regarding other doctor's care post-surgery. Dr. Sareen has operated the patient. The consent is taken from the patient for surgery by Dr. Sareen, but Dr. next day after the surgery is over. So in consent, it has to be mentioned that other doctors in the team, either by name or other doctors in the team, will be looking after, equally qualified or juniors under working under him will be looking after the patient in his absence. This fact has to be mentioned in a consent. Name of procedure not mentioned, alternative treatments available not explained, consent regarding non-availability of equipment, no separate consent for blood transfusion, no separate consent for anesthesia, no witnesses in high-risk consent, consent not taken before oral hormone replacement therapy, chemotherapy, oral MTP pills. We have a tendency to think that only interventions where we are intervening, that for that only consent is required. I'll give you examples when we have a session only on consent. I'll give you examples where you will see that even for oral drugs, you require to take consent under special circumstances. Then not taking a real and valid consent. Again, this will be taken up at a later session. The adverse consequences of using treatment, there are multiple examples, but I think again we will take it up later. This was a very, very strange judgment. Unfortunately, neither Indian Society of Gastroenterology nor Society of Gastrointestinal Endoscopy of India thought it fit to challenge this. Basically, what it said was that when you are doing this ERCP as a procedure, you need to detail the complications which you have faced in the past. It is not the complications as given by Indian Society of Gastroenterology or American societies. It is the complications you have done in the past. So if there is a pediatric surgery resident who is doing a procedure for the second time, he is supposed to write that the mortality rate for him is 100% because the previous patient died. I don't understand how training of doctors is going to happen if we have to give the complications, our own complications mentioned in the consents. This is the example where oral hormone replacement therapy consent was not taken and a criminal case was filed. Additional procedures like cannot be done except for what has already been consented. Then, before something adverse happens, we have some misplaced priorities. We don't prepare. We do not have standard operating procedures. We have design flaws in our hospitals. We don't have CCTV, panic buttons, safe rooms, emergency exits. All this becomes important when violence occurs. We have very poor training in communication. We have poor knowledge of law, refusal to learn from others' mistakes. We are kings of our castle. All of us are generals. We don't like to follow. We don't like to listen to others. Too intelligent for our own good. Refusal to integrate with local population, socially, religiously, politically. This is one of the basic flaws of medical profession in India. We simply refuse to integrate with local population. And this becomes important when some adverse event occurs in an isolated small or medium clinical establishment. Then the local population and your relationships there come into play. None of us probably will know who's the SHO of our local police station, but it is becoming more and more important to know that. During treatment, improper documentation. We are going to have a totally separate session on how what is wrong with our documentation. And these are the headings under which we will be discussing it when we take this thing up. But why is documentation important? Fine, the courts say very clearly that if you have not documented, you have not done. If you have poorly documented, you have not properly done. Also, if you die tomorrow, the case is going to continue. I have already told you this was Consumer Protection Act 2002 amendment. Civil Procedure Code is applicable on CPA 2009. And according to this, even with the death of parties, the case doesn't abate, the case will continue. So if you have died and your legal heirs are fighting the case, how will they fight the case if your documentation of the case is not appropriate? So for their sake, make sure you document everything what you do. And third, the indemnity insurers are within their rights to refuse to pay any compensation if you have not provided them with the documentation they need. Even to the extent that when you are doing a CPR, the courts expect us. Even when you're doing a CPR, the courts expect us to give a minute-to-minute record of at what time the cardiac arrest took place, what time, who noticed it. The kind of things which are being asked are ridiculous, but till the time somebody challenges and shows the honorable courts the true situation, we will have to abide by their orders. Look at the Kunal Saha judgment, 11.6 crores awarded. But was it awarded against the hospital which treated the patient? The hospital which treated the patient and where the patient died was Breach Candy Hospital. The patient remained there for 12 to 13 days and died over there. The patient remained in AMRI hospital only for 3-4 days and was airlifted to Breach Candy thereafter. But the entire compensation is against AMRI hospital. What had happened? The documentation at Breach Candy was exquisite. Even things which we normally do not document, we all have arguments with our patients' relatives. They documented each argument. If the doctor has ordered something and the Dr. Kunal Saha and his wife, they refuse to get that treatment started, the nurses documented that. Dr. Udwadia documented exactly what is happening, what they are insisting, what he's allowing, what he's not allowing. And all these things, when this was brought up in National Consumer Dispute Redressal Commission, they awarded 10% of the compensation of 1.73 crores, which was initially awarded by National Consumer Dispute Redressal Commission, as contributory negligence against Dr. Kunal Saha. This was a very unique judgment. There was so much interference by Dr. Kunal Saha in the treatment of his wife that he is partly responsible and he should also pay 10% as the contributory negligence fee. So when the case went to Supreme Court, Dr. Kunal Saha was advised to drop Breach Candy Hospital from the array of opposite parties. When Breach Candy Hospital was not party, all these documents where the medical records were created by Dr. Wadia and his team, they were no longer applicable, and it was only a case against AMRI Hospital versus Kunal Saha, which of course he won hands down. Similarly, you need to write the details of the procedure you are doing, not simply the ERCP done normal, not simply no ROP seen. These are the kinds of things we do routinely, but we need to expand our knowledge and we need to do this more properly. Tampering of medical records is something we need to take very, very seriously. And when we discuss the records in a future session, if we have an opportunity, I'll give you the details. So this is a criminal act if you are tampering the medical records. How long to preserve medical records? This question is frequently asked from me. Again, I think we'll take it up at a later session. Today, the Consumer Protection Act says 2 years, but then there is a discovery rule according to which it is 2 years from the time of when the patient discovered you had done negligence. So effectively, it could be any number of years. The Limitation Act says 3 years. Different acts say different things. Before destroying any records, definitely you should give a newspaper advertisement, and we will discuss this in detail later. So what are the mistakes during treatment besides the medical records? Improper communication. The doctor has said something else. The nurse is following something else. You have cases where in multiple countries, this problem has occurred, where injection methotrexate is to be given intrathecally and injection vincristine is to be given intravenously in cases of leukemia. This is standard protocol. But in a period of over, I think, 10 years, from 1968 till 2005, they studied this, and overall 55 cases of vincristine injection into the intrathecal space were identified across 6 continents, multiple countries. So this is something which needs to be looked into. This cannot be blame and shame. This particular doctor was negligent and there is a systemic flaw in the problem. We also have Spring Meadows Hospital versus Harjot Ahluwalia's case, where injection chloroquine was given IV instead of injection chloromycin. Muscle relaxant, unfortunately, we have had cases where was given IV instead of sedative. So all these kind of things result because of poor communication and poor protocols. While treatment is undergoing, you cannot force a patient to buy from the hospital pharmacy. And can resident doctors in turns be sued? Definitely. Even Kunal Saha judgment, the Supreme Court ordered compensation against a junior doctor, stating that junior residents cannot act as second fiddle during treatment and fail to apply their minds if they think the consultant is giving wrong treatment. Very noble thoughts, very magnanimous of the higher judiciary to think so, but in practice, as a junior doctor, if I ever thought of contradicting my consultant, I'm sure I would have got a boot up my ass and asked to leave the program rather than have anything else to do with it. Other mistakes during treatment, jousting. We tend to criticize the previous doctors, especially when the patient goes to higher institutions. Sometimes during teaching, the presentation of the case is going on, the case is being presented by a junior to the senior, but we forget that the patient is also listening. And a derogatory remark or a derogatory comment during the presentations or during the discussion reflects very badly on the doctor who has previously treated and can lead to problems for him, as also for you. During treatment, sometimes hospitals have certain policies, and those policies can also lead to problems. Like in this particular case, case from Delhi itself, Sundarlal Jain Hospital. They had a policy, patient comes in emergency, you treat, first aid is to be given free of cost, no issue. They gave the roadside accident victim treatment free of cost. Now the patient required admission in ICU. And the policy which was told to the doctors by the medical superintendent was get 25,000 deposited, only then admit patients to ICU. So they asked for 25,000. The people who had come with the patient, they took the patient to another government hospital. On the way, the patient died. Criminal case was filed against the medical superintendent who had not treated this patient. So we go into the pros and cons of this kind of a judgment, but probably on some later dates, because as I see, I'm already overshooting my time. So when an adverse event has occurred, there is panic all around. And this happens in government hospitals, this happens in private hospitals. 3 days ago, I was in a session with PGI, with the Department of Obstetric Anesthesia and the Department of Anesthesia and Obstetrics. Consultants were all there. The issue of death on table was discussed. And the policy told to me that the policy which exists in PGI is, we do not declare patient dead on table. We shift the patient to nearby ICU or nearby high intensity care unit. Now the problem is, we also have cases where the allegation is that dead body has been kept on ventilator. You are not only responsible for treating the patient in PGI or in teaching institutions, you are also teaching protocols to the residents who are not going to be working with you later. They are going to go in independent hospitals and be working in private sector also. In private sector, if they follow this policy, tomorrow somebody someday will make an allegation that you have kept a dead patient on a ventilator. So you have to look at all these aspects when you make a decision. Improper communication is there after an adverse event. There is an operation cover-up. Refer patient who has cardiac arrest on Ambu bag to a larger hospital with a nurse sitting in the ambulance without you yourself or the junior doctor going with the patient. Refuse to release dead body till payment is made. This is a major issue in some, though ethics of this can be discussed. But this is a major issue. Premature declaration, you have declared the patient dead and after some time the patient is found alive. Release of dead body in case of OT or unexplained unnatural death. You have had a sudden death of a young person in operation theater and you are certifying cause of death as cardiorespiratory arrest and giving the death certificate without knowing actually why the patient has died. This you require under section, I think 174 of CIPC, any unnatural death has to be reported to the police. Not advising post-mortem, not informing insurers, discarding any used syringes, ampules in cases of sudden death, and not having copies of Prevention of Violence Act and Jacob Matthews judgment with you if unfortunately an adverse event occurs. You have panic, shock, lack of coordination in emergency. Look at what happened in this particular case. There is a cardiac arrest which has occurred. The surgeon goes out to call the cardiologist. There is no call system by which the cardiologist could be called. Once the cardiologist comes, he is asked to change clothes and waste 20 minutes before he can enter to do the CPR. So these are the kind of things which happen. Autopsy in sudden death, sudden unnatural, unexplained death, mandatory. This is something which has to be understood. And criminal cases have been filed on this issue, so don't make this mistake. And in case of private hospitals, some of you will be working in private hospitals, when a catastrophe occurs, invariably press is involved. And when the press reporter asks you, you tend to get emotional and give a very detailed statement, which is then made to the newspapers and broadcast media. You don't interact with reporters regarding an adverse event. Sometimes people just shut up, and the next day the report will be published in full detail as per the version of the patient party, and the doctors could not be contacted will be the one line below. Please remember, when you issue a press release, it should not be more than 150 words. Why I say this? Because it is going to be printed. if you write a 2,000-word essay and give it to them, they are going to edit it, and what you want to say is not going to come into in the press or in the news. What they will pick up and what they will pick up from those 2,000 words will come, and it will be a problem. Don't hide your face from video cameras. Everyone from hospital team interacting with media is a problem. There should be one spokesperson, one team leader who should be interacting with the media. When dealing with the police, don't keep running to get anticipatory bail. Even in cases of death, you don't need that. Not having a prepared statement to give to police regarding incident, destroying all evidence, ampules, IV fluids, tubes, not noting down name and buckle number of police official you have given the information to, not numbering pages of medical records before they are handed over to the police, not mentioning that records are incomplete due to adequate time not having been provided, and not taking receipt of the documents. After receiving a legal notice, improper reply, do not give too detailed replies, because when you give a too detailed reply, invariably when the case is filed, the allegations you find are totally distorted. Do not try to do under the table settlement with patients. Any settlement which has to be done should be done either in Lok Adalat or under CPA. There is a mediation cell, because when you do it in court settlement, after that there is no appeal. But when you do out of court settlement, you have given some money, got some signatures on a blank paper, and said the matter is over. That paper itself is produced in court. The doctor was negligent. That is why he gave us 2 lakhs, and now we want 20 lakhs. Court supervised settlement is the best. Compromise does not also help in criminal cases if criminal negligence has been filed against you. When you receive a notice from court, please choose a proper advocate, reply in time. Do not do compassionate settlement out of court. Inform your insurers. Take personal interest in the case. Don't depend totally on advocates. To appear personally in court on important hearings. Try to give all evidence in initial stage. You may not be given the opportunity to improve your case later. And trying to hide the issue from your colleagues is bad. You will get positive responses, positive inputs from your colleagues. Please take that, and do not make conflicting statements in court. After an adverse judgment has come against you, not going in appeal is a problem, and this particular case is the classical example. Of course, this slide of mine is very famous. These are one of the most stupid mistakes we have all made, but yes, we can always be medico-legally safe by totally stopping to start practice. But we need to understand it is our overconfidence which is also leading to problems. Till the time we have actually had a problem, we refuse to listen, and this is the basic crux of the mistakes that we normally make. I hope I have not overshot the time. Thank you so very much.
Dr. Neeraj, I think thank you very much. You are bang on time. In fact, a couple of minutes earlier, but I'm sure there will be a lot of questions. It is just scary the number of scenarios that you mentioned, how familiar they are, at least to most of us. We have all been in these situations at some point or the other over the years, and sometimes when you look back, you just wonder how things did not happen the way it can sometimes happen.
उसको लड्डू बहुत पसंद आया है.
Madam,
वो
somebody
कभी-कभी दूसरा भी आके मांगता है.
Yeah, please, if you're on some other thing, can I request you to please mute yourself? Yeah. So I thank you very much, and I think this is like a small starter of all the good things that we are going to hear from you over time. I will ask Dr. Sareen to say a few words, and there are a few questions here which I'll probably put to you. Dr. Sareen?
Yeah, Neeraj, there are 2-3 things I must ask. One is that most of our pediatric surgeons, we get very attached to our children, and they will have stage surgeries. And it's very possible that a child that you operated at the age of 2 years, he doesn't want to go to there's no concept of transitional medicine in this country. He will not want to go to another surgeon at the age of 22 years. So I have been a general surgeon, all right, but I have been operating. I have operated patients even who are say 36 years old and they were lying in my ward. And of course, any surgery could have complication, even a simple appendectomy or, subacute obstruction surgery could have complications. Then what do you do about it? I mean, if you do not operate these patients don't want to go to anybody else. The entire family will come and hold your feet and say, "Nahi, nahi, aap ise karana hai, sari zindagi aap hi ke paas se rehna hai."
No, Sri, the point is, we have a case like this where a pediatric surgeon has operated a patient who is now an adult. And this is exactly the situation you are describing. The point is, my advice is always associate a general surgeon with you when you are doing this. There is no harm in associating somebody with you in the surgical team. That gives you the protection, because we like to hear this कि डॉक्टर साहब हमने तो हमेशा हर चीज आपसे ही कराई है. Please remember, the only case under section 302 which was filed against a doctor was against a gynecologist who had delivered 6 previous children of the same lady. It was in the seventh that she died, and prior to that she was God for them. So please get out of this God complex.
Now, Neeraj, the problem is in a private setup, no, if I am a pediatric surgeon, I call a OB-GYNist, or if I call a general surgeon comes running. But the actual experience of ours in government hospitals is you keep begging people, your colleagues from the other departments to come or take over the patients, and they will not take over. I mean, that is something which is very, very frustrating. I mean, you explain to them, you talk to them, you sit with them. The now child is 20 years old. Now I cannot be doing it. This is the procedure that has to be done. You please take up the patient to your department, your OT, and I will come and help you there. But trust me, all these patients who just sent for such a referral, they will going around in circles 6 months back. 6 months later, they will again come back to you. Okay, nobody is bothered, nobody is interested. You only have to do it.
There is no harm in keeping the patient in your ward, but have a general surgeon associated with you. This is for your safety, because what is happening in private sector today is not happening to that great extent in the government hospitals, but it is already happening. And tomorrow, these things are going to keep on increasing. And the issue is, once a death occurs, once a misadventure occurs, after that, they all forget what you have done in the past. So please save yourself, because if you don't do things, take steps to save yourself, you have a responsibility not only towards your patients, but you also have a responsibility towards your family members.
Second question is that of...
yeah, Dr. Sarin, 1 minute. Can I just ask Dr. Nagpal, can you just stop sharing your screen so that people can see all the people online?
No, I'm not sharing my screen.
He's not sharing the screen. Yeah.
All right. Okay. Fine.
Another thing, Neeraj, is that although you did talk about the limitation, but recently I'm going through a case which I had done in 2005. 5 inquiry committees have given me a clean sheet. Now you're sharing your screen.
No, this is being shared by Dr. Rao. This is not with me.
Yeah, no, this is, I think I've got the wrong one. Yeah, that's fine. I think I'll just go back to this. Yeah.
So 2005, a alleged negligence had happened, which was then complained to multiple authorities, and so many derogatory messages, and it was given into print media as well as the visual media and all that. But now after 15 years and 5 inquiries which had happened at every possible level, including the highest possible available forums available, now they have gone to court, and now they want the police to kind of so where is the limitation? And another thing which has happened recently is that because COVID, there was an issue, so courts have for every case anyway, they have added another 2 years to whatever limitations may be there. So what you mentioned is 3 years, so that is now 5 years if it has occurred in the year 2020 or 21. That is one. and the courts just don't bother. When the lawyer argues that this limitation period is long gone, the judge kind of just doesn't want to hear you out, you know.
No, Dr. Sareen, you have misunderstood me. Limitation period is in civil jurisprudence.
Okay.
Limitation period has nothing to do with criminal law.
Right.
So a criminal case can be I can be prosecuted for a criminal case if I have murdered somebody 20 years ago.
Yeah, that's right.
It does not mean I will go scot-free because of Limitation Act, the Limitation Act.
Yeah.
So this limitation period is only for civil cases, number one.
So,
number
so
two,
how would you decide what, what complication or what negligence, alleged allegation can be treated as civil, or what can be treated as criminal now?
So the problem is, it is the misfortune in India is Jacob Matthews judgment which came in 2005. This defined what is criminal negligence and what is civil negligence. Unfortunately, when you read it, it mentions certain things which are outright cases of negligence should only be considered as criminal negligence. We all celebrated this judgment, but actually this judgment was very, very harmful for doctors. Because when you go back to VP Shanta and others' case, they had given the same examples. You have operated on the wrong foot. There cannot be anything more obvious than this. But that also, they said, is a case to be taken up under Consumer Protection Act. They did not say it is to be taken up under criminal law. Jacob Matthews has made it criminal negligence. And what happens is, when a patient files a case against the doctor to the police, one thing, you should be thankful, all the 5 inquiries which have been held by you, none of the inquiries has been held by CBI. We have case in PGI where a judge's mother was not attended promptly. Please understand each word I'm saying. And a CBI inquiry was marked to inquire into this incident. You understand the implications. Then, when a police gets a case, they refer it to a medical board, to the civil surgeon. The civil surgeon, the doctors sitting there, they have no concept of what is civil negligence, what is criminal negligence. And if I tell somebody, you write over there, this is a case of simple negligence, it does not matter to the policeman. The policeman says, we simply want to know whether there is negligence or not. If there is negligence, the FIR is lodged and the prosecution starts. Then it is up to the courts to say, yes, this is a case of civil negligence, so this FIR should be quashed. But the process of criminal prosecution in India, 2 years, 3 years, 4 years, which you undergo, that itself is the punishment for doctors. They don't require to be incarcerated in jail. So this is what is happening, and unfortunately, we seem to ignore these things. I have been speaking on these issues for a very, very long time. You know all this. But the problem is, until and unless it hits somebody on the head, people just don't seem to realize the magnitude of the problem.
Yeah, there are a couple of questions on the chat group. One of them, Dr. Akshay, he says, ours is not an organ-based specialty. How safe is it to practice, example, endoscopy, treatment of urinary trauma, chemotherapy by surgeons, etc.?
So the problem is, we have created this super specialty culture. If you are asking me, an MBBS doctor has the absolute right to be practicing pediatric surgery if he has trained under Yogesh Kumar Sareen for 20 years. Supposing he had been working in the department for 20 years, why does he not have the right to practice pediatric surgery? We have gone from, we have totally emasculated the MBBS. And now gradually that emasculation is extending to MS. Gradually that emasculation will go to even MCH pediatric surgery, because there also they will start saying you need fellowship in pediatric surgery gastroenterology, you need pediatric surgery oncology, you need pediatric, somebody will someday will want to come up with MCCH in pediatrics oncosurgery. How are you going to stop this? The point is, we have to move back from the super specialty culture. Yes, it is better that a case of pediatric surgery is operated by a pediatric surgeon. But a doctor who's MBBS, who's trained in pediatric surgery, if he is operating, it should not be considered illegal. This is my personal view. And unless and until we go back to this, because I was giving a talk in Foxy and somebody was talking over there, we need to start a fellowship or we need to start an MCH program in infertility. Now, the problem is, it is very good to start an MCH program in infertility, but the moment you start that, you imagine 5 years down the line, all the MD or MS obs and gynae people who are infertility specialists today, suddenly they will become illegal. So we need to rethink which direction we are going. And this is doctors themselves who are promoting this problem for ourselves. We are not, this is not outsiders who's doing this.
Yeah, no, I think we are going through a similar thing in pediatric surgery also, especially with things like pediatric urology and things where there is, this whole focus. So I think that is something that we will take up. I think the one more question is, it says, is there a legal upper limit for pediatrics in our country? I think we had this discussion within our groups as well, so IAPS says 18, yeah.
No, there is a Indian Majority Act, which says a person more than 18 years is a major. Please remember, a person who's 18 years, he can adopt a child. All right? A person who's 18 years cannot get married. He can get married only when he is 21. We are talking of males. A male 18 years in India today can adopt a child. He cannot get married till 21. And he cannot have his first drink, alcoholic drink, till he is 25 in some states. The Indian Penal Code says you cannot take consent of a child less than 12 years. So we are silent between 12 and 18 years. That is why I said more than 18 years we know is an adult. Less than 12 years we know is a child. This 12 to 18 years, please take consent both from the child as well as from the parent. When we have a session on consent, we will discuss this in more detail.
One last question, it says is, sir, in this scenario, this is, I think, a trainee who is asking, can residents in pediatric surgery who haven't completed their training operate as a general surgeon?
So the
I don't know why he wants to do it, but
we have to fight for this.
I don't know why you
fight for this. An MBBS, again, I'll come back to my basic this thing. An MBBS, what is MBBS? He's a Bachelor of Medicine, Bachelor of Surgery. You have given me a training in surgery, and if after that I have worked in an institution like CMC, like PGI, like GV Pant, like any other institution, and I have received training in the department, what is wrong with the MBBS doctor performing surgery as long as he is not claiming to be an MS? The person who's approaching him should know clearly that he is not an MS surgery. He should make it very, very clear he is not MCH in pediatric surgery. Because by this argument, your point is absolutely valid. All the residents, when I'm doing MD medicine, and when I'm posted in cardiology, there I suddenly turn into a cardiologist and treat all the cardiologists. At that time, I'm simply MBBS. I'm not even MD. You understand the gravity of the situation. An MBBS who has got MD medicine and he is under MD medicine training is posted in cardiology. When he is posted in cardiology, I am sitting in ICU also. I'm monitoring patients there also. There I am practicing. It is supposedly under supervision. Is it actually?
I think this is more and more questions rather than answer. I think it's just very desperate in the sense that I think there are so many judgments that come that often don't seem related to one another. It's not a logical sequence. It seems to be going backwards and forwards, and getting it all together. It's easier to find something to whip with rather than to build, something as a consensus. I think that's about how it seems to look like as we are going forward. I think we are sort of coming to the end. I can't see any more questions.
Neeraj, one question more is that if I'm MCH in pediatric surgery and also MS in pediatric surgery, you must understand that there are also 6-year courses in pediatric surgery after MBBS. But I'm a general surgeon. I'm a qualified general surgeon. I have worked as general surgeon for a couple of years. Then can I operate on a adult just because I have now got another degree in doing super specialization in pediatric surgery? Does that bar me to operate on adults? I'm a MS general surgeon.
In my opinion, I have already answered very clearly.
No,
You have the absolute right.
Not your opinion. What will the court say to this?
The court, I have given you a stupid court's judgment.
Yes,
I have given you a stupid court's judgment, which is saying MCH urology cannot do a cholecystectomy. My question is why? He's MS surgery before he's MCH urology. But these are the kind of stupid judgments we get, which depend totally on whether the judge has fought with his wife on the day of the judgment or not. It is not dependent on the facts of the case.
I think Dr. A.K. Sharma has a question or a point to make. Dr. Sharma?
Yes. Can you listen or can you hear me?
Yes, sir.
Yes, sir. We can go hear you.
Yeah. My simple question is that I've got an indemnity policy with me, which states that I can operate in any hospital anywhere in India. Do I need to mention that in Jaipur I'm operating in these 2-3 hospitals, or it covers?
Ideally, you should mention the hospital name where you are operating and in other hospitals as and when called.
Okay.
So it is always better to mention that we have fought with many insurers on this issue, and now the policy wording is saying what you are saying. But we have judgments earlier when this was not the scenario, and the insurers, because in insurance company, you have people who are paid specifically for this job to find excuse to deny liability where it is due. So doctor is negligent, court has awarded, indemnity insurer says, fine, doctor is negligent, court has awarded, but we are not liable to pay because of XYZ reason. Why give them a reason?
Thank you. Thank you.
I think there's just one more observation. It says, sir, can a MBBS MD in biochemistry or any paraclinical specialty practice as a GP? There is a question. And there is an observation that says logic in medicine is different from logic in law. So your comments on this, and then we will close.
I am back to my original ground, and I'll stand by that ground, and I'll defend it in Supreme Court also. An MBBS is an MBBS. He can practice surgery, he can practice gynae, he can practice medicine, as long as he does not claim to be a specialist. There is nothing wrong. If he has taken an additional degree in biochemistry, if you have taken an additional degree after MS in pediatrics, MS surgery in pediatric surgery, does not mean, this is exactly what Dr. Sareen is saying, that he cannot operate on an adult patient. Why not? He is trained and qualified to operate on adults also. But this is something our judiciary needs to be explained to, and one person shouting at the top of his head is labeled as a psychiatric case, but when the same message is coming from seniors and academic organizations, I feel someday the situation will change, and we are getting some judgments from Supreme Court which seem very rational now.
Right. I think on that sort of positive note, Dr. Nagpal, I think we will end this session. I think we have had more than 100 people here, partly on Zoom and partly on YouTube where this was streamed. And there is a universal sort of happiness and congratulations on the material that you have conveyed and the timely manner that you have done it. And I think we will look forward to more of these more specific talks on each of those topics that you raised during the first this particular talk. I think on that note, I think Dr. Sareen wants to say something.
Neeraj, you went very fast through the slides, and we need time to kind of absorb them. So what I suggest to Sanjay is that we will have far more number of sessions, but this is something you should teach us, to slowly and with patience. We have a lot of issues on this. One issue I wish to ask you is vicarious liability. Some other talk, maybe you should kind of consider that also. So with that, with folded hands, what was your roll number in MBBS? I forget.
You would be the one remembering, not me.
I usually remember. I think it was about 40 or so. And
35 or so.
yeah, and mine was 50. Yes.
Your memory is always phenomenal. I mean,
so thank you very much, and we gained so much from you, and all through this year we're going to learn more and more from you, and thank you very much for giving us our precious time. Thank you.
Thank you, Dr. Nagpal. Thank you very much, and thank you for all the people who are on this webinar. We will announce the next one. We are hoping to do this at regular intervals, and we will announce it in due course of time. The presentation will be available on YouTube. So those of you who have missed it, probably you can log in and see it there as well. So thank you very much to all of you all, and we hope to see you in the near future. Special thanks to Dr. Nagpal. Thank you very much, sir. Thank you.
thank you, sir.
Thank you. Good night. Good night, everybody. I will end this session.